Hello, kids. Welcome to the Fearless Floyd Show. As always, I am your host, the fabulous Fearless Floyd. And for all of you out there who are giving me other monikers, thank you for that. I appreciate you putting me in your mouth and on your fingertips. If you need to reach me, fearlessfloydshow at yahoo.com. Go to my Telegram channel, same name. Like, subscribe, hit the notification bell, share this video, do whatever you want. So, if you don't want to watch it, turn it off right now. I'm not tripping. If you want to unsubscribe, unsubscribe. I'm not tripping. If you don't want to watch, don't watch. If you don't want to hit the like, hit the dislike. I'm not tripping. This video ain't for you, clearly. So for all of you others out there, I've just been wanting to present this case because I talk about this case all the time. This case is, well, here, let me pull it up for you guys. This is a case I actually worked on, not for myself, but for somebody else. And hang on. There we go. I got to get the right one up. There we go. Yeah. All right. Texas Judicial Branch is the 14th Court of Appeals, which I've always told you guys. Okay. This was appealed from the Walker County District Court. It's the case number right there. Here's the style. Alan Wade Johnson versus Thomas Alson Davis and Gary L. Johnson. Gary L. Johnson was the director of TDCJ. I really don't know who Davis is. It doesn't ring a bell in my memory. But as you can see, it's an inmate lawsuit filed in TDCJ. And it was filed March 11th, 2004. And I think by the time I got it, it was 6 months later, maybe. West Publishing. Appellate briefs. Man, I wish I could pull these up. I don't even know if I can order them because they destroyed this file. Uh-oh, hang on. I've got an interloper. I'm doing a video, Jesse.
Oh, all right. Well, we're here, brother.
Oh, okay. Well, I'll come unlock the door and then finish my video.
Sure.
Mm-hmm. All right. You guys hang right there. Let me go let my guest in. I am back. Yes, I am. So anyway, as you can see right here, this is the events in the case. You can roll down. You can see it was filed February 9th. Judgment signed by trial judge. And it goes all the way up to 2006. Case stored. 2014. Case file was destroyed per retention schedule. Maybe the paper physical file was destroyed, and hopefully there's a digital copy. I'm going to try to get the state's brief and the traverse to the state's brief that I did. But anyway, you can see everything that happened here. You can go look this up yourself. Represented by the Attorney General's Office of Texas, coming out of the 12th District Court, Walker County. William McAdams, who is, I don't even think, this is like a visiting judge. Because I believe this was Keeling's court. Keeling's dead now, and Keeling was so old and feeble he couldn't handle the caseload, so they brought in a visiting judge who pretty much ran the day-to-day operations there. That's Keeling's the guy I argued with in the Walker County grand jury room while I was bound like the inmates on Con Air, trying to argue and go through documents like this. Yeah. Ankle chained, waist chained, handcuff box, which means your arms are locked like this, can't turn your wrists, chained to a belt. Yeah. Yeah, that's how they do you. So anyway, here's the synopsis of the case. Pick it up. And here's the citing. 178 Southwest 3rd, 230, 2005. Okay, so when I tell you guys I'm published, this is part of the stuff I did, that I am published. Here it is. This isn't my case, but I definitely filed the traverse to the state's rebuttal brief. Absolutely. Alan Wade Johnson, yeah. You're going to see it right here. Background. Appellant Alan Wade Johnson is an inmate serving a life sentence for a 1994 conviction of aggravated robbery. He's incarcerated in the Texas Department of Criminal Justice Institutional Division. Appellee Thomas Alson Davis is director of the Texas Department of Public Safety, hereinafter as the TDPS director. Appellee Gary L. Johnson is the executive director of the Texas Department of Criminal Justice, hereafter referred to as the TDCJ executive director. The Attorney General of the state of Texas represents both appellees. And Johnson was on the WIN unit with me. And basically, in May 2003, Johnson filed a pro se lawsuit in Travis County, Texas, because that's where TDCJ has bifurcated headquarters, one in Austin, one in Huntsville. So they have two addresses. So he filed it in Travis County, hoping to get a more liberal and friendlier court, and they kicked it right back to Walker County. That's where he was incarcerated, which is an appealable error. In their official capacity, seeking injunctive relief and judgment declaring that the Texas DNA statute violates the Texas Constitution. Johnson alleged that this statute allowed a University of Texas medical branch nurse to take his DNA without his permission, resulting in a civil assault. Johnson sought no damages in his original petition or in any subsequent pleading, but sued only for injunctive and declaratory relief. Basically, what he's doing is he's suing to prevent the DNA database from being conducted. Declaratory relief where they admit publicly that they're violating the Texas Constitution. The Department of Public Safety Director and TDCJ Executive Director filed a motion to transfer venue from the case of Travis County to Walker County so they can get a friendlier county to the penal system. The trial court granted the motion and transferred venue of the case to Walker County. Before the Travis County courts signed the transfer order, Johnson served requests for admissions, interrogatories, and requests for production of documents on the DPS director and TDCJ executive director. Before answering the discovery, the director and the executive director filed special exceptions to Johnson's pleadings, purportedly seeking more specificity with respect to the nature of the acts or omissions they allegedly committed. I mean, this is like a real clean-cut case. There's no really, you're taking my DNA and you're going to use it against me in a future proceeding. So I'm being compelled to give evidence against myself. Okay. And he also cites Article 1, Section 9 of the Texas Constitution in here, which I'll get to in here in a minute. And additionally, they argued that they were entitled to official and qualified immunity, and that they were entitled to a more specific pleading with regard to allegations purportedly made against them in their individual capacities. They argued that because the state had not waived immunity, the trial court lacked jurisdiction over suit for damages. The DPS director and executive director sought a protective order from the trial court pending resolution of the jurisdictional issues. A protective order? Johnson filed responses to the special exceptions and motions for protection, in which he pointed out the suit had never involved money damages, and that neither the director or the executive director had been sued in the individual capacity. Johnson's pleadings supported these arguments. Nevertheless, the trial court granted the special exceptions and the motion for protection. Okay? Now, they admit it right here. Okay? Johnson's pleadings support these arguments. You're a winner. Nevertheless, we're going to make you lose. Okay? That's how these fuckers roll. And we're going to get into some more. So, when I tell you guys, this is the corruption that I personally experienced, okay? I've seen with my own eyes. Been involved in it. You're looking at it right fucking there. Okay? Hate to be coarse, but that's how it is. The DPS director and TDCJ executive director then filed a traditional motion for summary judgment in which they asserted that they were entitled to judgment as a matter of law because at least one element of each Johnson's claims did not exist or all elements of their affirmative defenses were conclusively established. Johnson filed a response to the motion for summary judgment in which he complained that there had not been adequate time to conduct discovery and on this ground requested continuance. In addition, Johnson addressed each of the grounds asserted by the director and the executive director in their summary judgment motion. The trial court granted the motion for summary judgment and dismissed Johnson's case with prejudice as frivolous and malicious and failure to state a claim. Because that's how they roll in Huntsville. And we're coming to get you, Huntsville. Walker County. Yeah, we're coming. That's why I'm partially making this video. To share with these other people who are going to come after you and your ilk. Your corrupt, evil, satanic ilk. We're coming for you. I'm going to get you too. Yeah, no doubt. Issues presented. Johnson raises 5 issues on appeal. First, he claims the trial court erred in applying the law with respect to the director and executive director's motion to transfer venue. And a second issue, see, this is what these assholes do, is they get you off your main topic. His main topic was Article 1, Section 9, Article 1, Section 10 of the Texas Constitution. Okay? That was his argument. Now they got him taken off on all these rabbit trails to try to defend himself, to get his case back on track so we can hit those issues. Okay? So now you got to bring up all these other freaking claims. Because this is how they roll. They want to get you distracted. They want to get you running over here, over here, over here. Look over there, look over there, look over there, look over there. So you're not looking here. That's how they operate. Okay? Johnson raised 5 issues on appeal. First, he claims the trial court erred in applying the law with respect to the DPS director and executive director motion to transfer venue. In a second issue, Johnson claims that the trial court erred in granting the director and executive director's motion for summary judgment and in rejecting his constitutional challenges to the DNA statute. In his third and fourth issues, Johnson asserts the trial court erred in ruling on various discovery matters. In his final issue, Johnson asserts the trial court erred in ruling on the DPS director and TDCJ director's special exceptions and granting them a protective order. You just can't make this crap up. And this is crap. Johnson claims, this is on venue, okay? So we're not even going to, I don't even want to address the venue because venue should not have been challenged. And it should not have been transferred. It should have stayed in Walker County, or Travis County rather, not been transferred. They're trying to say because Johnson was in Walker County at the Wynn unit in Huntsville that it should be in Walker County. However, when Gary Johnson is the executive director and he's in Travis County at 500 Shoal Creek Boulevard, I believe it is. And then, of course, the DPS headquarters is in Austin, Texas, Travis County. So anyway, so I'm just going to skip. So summary judgment. Johnson asserts trial court erred in granting the director and executive director's motion for summary judgment. In reviewing a traditional motion for summary judgment, we take as true all evidence favorable to the non-movement. And we make all reasonable inferences to the non-movement's favor. Okay, so Allen didn't move for this. The director and the executive director did. Okay, so everything's in the favor of the non-movement. Allen. If the movement's motion and summary judgment evidence facially establish its right to judgment as a matter of law, the burden shifts to the non-movement to raise a genuine material fact issue sufficient to defeat summary judgment. Though Johnson did not assert any challenge to the Texas DNA statute under the United States Constitution, okay, did not. Here you go. Although Allen Wade Johnson did not assert any challenge to the Texas DNA statute under the United States Constitution because he only addressed it under the Texas Constitution. Article 1, Section 9, and Section 10. Okay? Here, they even state it. But listen, he claims this statute violates the Texas Constitution in several respects, and that these constitutional infirmities entitled him to injunctive and declaratory relief. Other Texas courts of appeals, as well as federal courts, have rejected the arguments Johnson makes. For the reasons explained below, we too conclude that the Texas DNA statute does not offend the Texas Constitution. For the reasons explained below. Okay? All right. Search and seizure. This is Article 1, Section 9 of the Texas Constitution, which provides the people shall be secure in their persons, houses, papers, and possessions from all unreasonable searches, seizures, and searches. And no warrant to search any place or to seize any person or thing shall issue without describing them as near as they may be, nor without probable cause supported by an oath or affirmation. Id, which is Texas Constitution, Section 9. Okay? Parties have not cited. We have not found any appellate court decision holding a DNA collection statute unconstitutional based on constitutional prohibitions against unreasonable searches and seizures. Nonetheless, cases upholding the constitutionality of DNA collection statutes in this regard have employed two different analytical approaches. See State versus Transal, and which is a Tennessee case. And as I've said before, repeatedly, especially in my Chris Hauser videos, how Texas and Tennessee law really commingles and emulates each other. Okay? Because the constitutions are very, very similar, if not the same. Listing cases that use either two approaches analyzing whether DNA collection statutes violate constitutional prohibitions against unreasonable searches and seizures. A majority of the courts have upheld these statutes under a traditional assessment of reasonableness, considering the totality of the circumstances. See, e.g., example given, Grossman versus United States Department of Justice, which is a Fifth Circuit case. And it was done per curiam, so no judge or panel sat out there and put themselves on Front Street. They did it anonymously. This balancing test weighs the governmental need for the action against the privacy concern of the individual affected. See the same case. On the other hand, a minority of courts have analyzed DNA collection statutes as falling within the special needs exception to the warrant and probable cause requirements. See example given, and this is this minor case that I was telling you guys about. Okay, that's why there's three initials here, because that's the minor, and they can't disclose their name. And this was to protect the minor. And here's the citing. Click on it. This pops up. And I wonder where I've seen this name. Let's see. Kimberly Colley McCary. Where I seen that name? There's Mandy K. McCary. Wonder if they're related. Just crazy little stuff like that. Okay, so we're going to scroll down. Oh, yeah, that case popped up. Facto. Oh, okay. I see what it did. All right. This is the minor case, and I'm going to show you exactly what I found when I read this case. Constitutional issues. So we're going to look, they're going to bring up Article 1, Section 10, as well as the Fifth Amendment. Yeah, I actually had to read this. This is, when I reviewed this case to do the traverse to the state's rebuttal brief, I had to go read every one of these cases that were cited, make sure that they were cited correctly or misquoted, as I'm getting ready to show you is done. So you can see how like the fifth Kennedy factor. These are all when you're dealing with all this legal stuff, you have to know this stuff. Basically, standards of review elements. Search and seizure. Much different reading these cases digitally than it is looking at them in a book. Here we go. All right. Appellants argue in their third issue that ordering them to place their DNA samples in a DNA database for the purpose of investigation and prosecution of future crimes violates their rights against self-incrimination under the United States and Texas constitutions. Their argument is based on the dissent in Schmerber, which emphasizes the testimonial value of a person's DNA imprint, on their assertion that the Texas Constitution provides greater protection against self-incrimination than the United States Constitution, and on their understanding of ex parte Renfro. The state responds that a blood sample is not testimonial in nature, thus the DNA statute does not violate the self-incrimination clause. Okay, of course it doesn't violate the Fifth Amendment because that's testimony, not evidence. That's why you get greater protection against self-incrimination under the Texas Constitution, Article 1, Section 10. Okay? The Fifth Amendment to the United States Constitution states no person shall be compelled in any criminal case to be a witness against himself. U.S. Constitutional Amendment 5. In applying the Fifth Amendment privilege against self-incrimination, the United States Supreme Court draws a distinction between a suspect's communications or testimony and real or physical evidence obtained from the suspect. Schmerber versus U.S. While the Fifth Amendment protects a suspect from being compelled to provide evidence of a testimonial or communicative nature, it does not protect a suspect from being compelled to provide real or physical evidence. In Schmerber, the Supreme Court held that a compelled extraction of a blood sample and its chemical analysis for blood alcohol content does not amount to testimonial or communicative evidence and therefore is not prohibited by the Fifth Amendment. Likewise, the Fifth Amendment privilege against self-incrimination is not violated by the taking of blood under Texas Family Code for DNA analysis. See Schaefer, Belgrade versus Montana, Bowling, Vore, Renard, Forrest, etc., etc., etc. Okay. Moreover, Renfro does not support appellant's position. In Renfro, the court analyzed the condition of probation that required the defendant to take a polygraph to determine whether the condition violated the privilege against self-incrimination. And I can keep reading. Okay. Therefore, the issue is not ripe. We hold that the Texas DNA statute does not violate the self-incrimination clause. Appellants have failed to demonstrate that, as applied to them, the Texas DNA statute violates the self-incrimination clause. We overrule appellant's third issue. Okay. Factual sufficiency of the evidence, and this is exactly what Chris Hauser just addressed in his presentation before the Tennessee Supreme Court on his forgery charge. And you're going to find that it's the same everywhere. Legal and factual sufficiency of the evidence. We also have a sufficiency of the conviction. So I'm going to scroll down because I believe I'm looking for the holding in this case. Somewhere it specifically talks about the fifth in the 10th section. All right, footnote 13. Appellants cite no cases supporting and do not separately analyze their contention that the Texas Constitution confers greater protection in this area of the law than the federal Constitution. Therefore, we will not address their state constitutional arguments. So, in this case, they did not address Article 1, Section 10. There it is, black and white. They only addressed the Fifth Amendment. Okay. However, when you go back to this case, Alan Wade Johnson versus Davison Johnson, I believe it is. Yeah, Davison Johnson. Could have been Johnson and Johnson, huh? Uh, submissions, rulings, abuse of discretion. Here's Allen. Allen complains that the special exceptions were based on, quote, dishonest pleadings that had no basis in law or fact, unquote. Because that's how they roll. They don't do anything under oath. It's all fiction, lies, bullshit. They say what they want to say when they want to say it, and everybody agrees with it, except you. So, back up. Special exceptions, other rulings, that's the protective order. Motion to compel, that's a source. We cannot say the trial court abuses discretion in allowing the late filings of these discovery responses and objections. Accordingly, what the hell just happened? Oh yeah, I'm back. At least I thought I was. So let me get back over share screen. Dive right back into Alan Wade Johnson. Now I want to show you these guys. This right here, just so you know. To establish a prima facie claim for civil assault, the plaintiff must establish the same elements required for criminal assault. See Moores Inc. versus Garcia. Under Texas Penal Code Section 2201A3, an assault occurs when a person intentionally or knowingly causes physical contact with another person when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. Texas Penal Code 2201A3. In his petition, Johnson alleges that Carla Holman, the phlebotomist, allegedly acting as an agent of the TDCJ executive director, took a blood sample from him without his permission. In their motion for summary judgment, DPS director and TDCJ executive director assert that Johnson could not pursue a viable claim for civil assault against them because neither they nor their representative agencies were involved in the actual taking of the DNA specimen from Johnson. They further assert that they could not have assaulted Johnson because neither of them came into contact with Johnson. There's a thing called law of parties. Look it up. An appellant's brief must contain clear and concise argument for the contentions made, with appropriate citations to the record. Texas Rules of Appellate Procedure, Rule 38.1H. We must interpret this requirement reasonably and liberally. Republic Underwriters Insurance Company versus Mextex Inc. However, the parties asserting error on appeal must put forth some specific argument analysis showing that the record and the law supports their contentions. Texas Rules of Appellate Procedure, and the abbreviation for that is TRAP 381H. See San Saba Energy LP versus Crawford. In his opening brief, Johnson lists assault as one of his 7 constitutional challenges he asserted in his petition and argues that, quote, the seizure of his DNA amounts to a confession wrestled from his body by physical assault, unquote. He does not, however, provide any argument, analysis, or citations to any legal authority or to the record demonstrating that the law and the record support his contention that the taking of a blood sample from him without his consent constitutes civil assault, or addressing the summary judgment grounds asserted against this claim. In his reply brief, Johnson denotes a third of a page to responding to the argument of the DPS director and TDCJ executive director, which I drafted, addressing Johnson's civil assault allegations in his petition. The brief provides no citations to the record or to any legal authority, because there isn't any. Even under a liberal construction, Johnson's appellate briefing on this issue is not sufficient to articulate a clear and concise argument as to why we should reverse the trial court judgment. Because Johnson's civil assault is inadequately briefed, he has waived this argument. Having found that Johnson waived his civil assault issue and that the trial court correctly granted summary judgment as to Johnson's constitutional challenges, we overrule Johnson's second issue. Now, let me explain to you what happens in the Texas Department of Criminal Justice if you don't provide DNA. They will literally send what we call the Ninja Turtles, which is a full SWAT helmet, shield, baton, chest plate, shin guards, elbow pads, the whole frickin' 9 yards. And they send the fucking Ninja Turtle team in on you. And they will fucking... They will pepper spray your ass. Then they will pin you on the ground. They will handcuff you and hog tie you. And then they will carry you to the infirmary. And if they have to, they will sedate you. And then they will get their DNA sample. And then they'll put you in seg and lock you up for pre-hearing detention for failure to obey an order. Absolutely. That's how that works. 100%. Okay? So what these courts do, as I've shown, they're operating in fucking fiction land. Nothing's real. Remember that. They just lie their ass off. Say whatever they want to say. They don't care what the law says. That's why they say this was inadequately briefed. But it was briefed correctly. That was a winning brief, or actually traverse, absolutely. And then we get back here to the third issue. And yeah, we did that. Compel for sanctions, and this is their argument. And fucking, this court is so corrupt. So anyway, I've already shown you what's going on. He was not suing for damages. Okay. It says it right there. Made some inaccurate statements, including the following. Judge he was suing for damage. He did not ask for a fucking penny. That was not what we were asking for. Injunctive and declaratory relief. That's it. Because when you get into damages, you get into a whole new ball of wax. That opens up a whole new area. Some more defensive you have to have, and that's not what we were doing. Not how we rolled. So, yeah. Courts are corrupt. Anyway, I want to go through with you this case. And because this case is a case of great constitutional magnitude, which means that it would affect more than just Alan Wade Johnson. It would affect every convicted felon in the state of Texas that's ever given DNA for the database, which they're currently at 2 million plus offenders in the state of Texas gone to TDCJ. And that's just what have been to prison. That doesn't include what got paroled in absentee at POA out of the county jail. And then you have the other legal ramifications in other jurisdictions, which are all the other states, as you see, as in this case where they cite Tennessee. So yeah, obviously it would have an effect on other jurisdictions. And it would set a precedent to open up the door for everybody to get rid of all this DNA database, so they couldn't track a 2021 rape with a 2022 conviction of a felon who committed the rape by DNA matching. So, can you be compelled to give evidence against yourself? Absolutely. In the state of Texas, will the district courts, courts of appeals, and the Texas Supreme Court uphold the Texas Constitution? Absolutely not. So, there you go, folks. There you have it. Alan Wade Johnson. All right, Alan, with you. I believe he's in federal custody now, because I know he had some Fed time stacked on top of that life sentence he had for aggravated robbery. So more than likely, I'm going to guess he did about close to 20 flat on that ag rob. Made parole, took him to the feds. So I should send him a card. Tell him hello, huh? I think I'll do that. All right, man. Well, thanks for visiting me. The Fearless Floyd Show at yahoo.com. I'm on Telegram. Hit that like, subscribe, notification bell, share the video. If I missed anything, leave a comment below. Yeah. In this case is an exemplification of why Chris Hauser will lose in the Tennessee Supreme Court. Just like that case, they're not going to open up a constitutional magnitude precedent to allow anybody and everybody to file a fraudulent lien on them. Nope, ain't gonna happen. Just like they would not allow this DNA database. Okay, I've showed you in here where they lie clearly. So, thanks for watching. Hope you have a nice day, and stay tuned. Got more videos coming up. Oh, we're doing a live tonight too, by the way.